Right, hello again. Let us now delve into the details of the A.K. Gopalan case. We have spent a significant amount of time, a sufficient amount of time definitely, looking at the lead up, looking at the background and all the happenings and some legal definitions as well. Some would say we have spent too much time, but because this is the first time that we are dealing with an actual case, I thought that we should spend a little bit of time looking at these intricacies because just the first time we don't want to overwhelm ourselves. This was also, of course, the first time that the Supreme Court of India was hearing a fundamental rights case. The judgment was given by the Supreme Court on 19th May 1950. So the case was decided within 4 months of the birth of our republic. A very famous and important case for several reasons, therefore. The facts of the case are quite straightforward. In future cases, in future judgments, we will see that there can be some convoluted and complicated facts. They are very straightforward over here. Within a few days of the Preventive Detention Act being passed by the Parliament of India, as it was at that time a unicameral legislature, the Constituent Assembly converted into the Parliament. They passed it on the 25th of February 1950. 4 days later, 1950 not being a leap year, 1st March is when the government of Madras, the state government, passed an order under Section 3 of that Preventive Detention Act, the brand new act, and the order was to detain Mr. A.K. Gopalan. Interestingly, Mr. Gopalan was already being detained, and this additional detention was added to his existing extant one. Now, why was he already being detained? He had actually been in and out of prison for almost the past 3 years, since 1947. That does not make him a recidivist and that does not make him a history sheeter. He was not being punitively imprisoned, none of those cases. Each of the times he was being preventively detained, because as you might recall the provisions of the Preventive Detention Act and also Article 22 of the Constitution of India, that detention can be whenever the state authorities feel that that person might act in a manner prejudicial to the defense of India, the security of India, the relations of India with some foreign power, or public order maintenance, and that's a pretty decent list. How did Mr. Gopalan happen to fall foul of that list? He was a leader of the Communist Party of India, and it was feared at that time that there was a possibility, a likelihood, perhaps even a probability of a communist insurrection in India. It had already been attempted once in what is today Andhra Pradesh and Telangana, and the communist leaders were quite powerful. They had quite a good hold on the people of the country. Interestingly, Mr. Gopalan originally was a member of the Congress. In the 1930s, he was a member of the Congress Socialist Party. Those of us who have studied the freedom struggle will remember that particular segment of our modern history. Later on, Mr. Gopalan rose through the ranks of the Communist Party, and most of his detentions were because of speeches that he had given. In some of them, he had criticized the police and he had advocated resisting police and state authorities, and that was sufficient reason for the various governments to do that. Granville Austin's book mentions that he had also approached the High Court of Madras, where his detention order was cancelled by the High Court judge at that time, who later rose to be our Chief Justice, Mr. K. Subbarao. So he has, Mr. Gopalan had a significant amount of history as far as preventive detention was concerned. What is interesting here is that as soon as the government of Madras got the opportunity, they detained him under the provisions of the new act, meaning that they could apply some of the exceptions provided by that act, which could continue his detention beyond 3 months. That was one of the reasons why we saw the act was so hastily passed. It was almost a scramble to get it passed before the Calcutta Communist Party members had to be released. So anyway, that was what happened with Mr. Gopalan, and he immediately challenged the legality of the order passed under Section 3 of the Preventive Detention Act 1950. He approached the Supreme Court under Article 32(1) of the Constitution. The judgment also mentions that this was the 13th petition that the Supreme Court had received in 1950. Unfortunately, none of the others made their way past the threshold of the Supreme Court. The writ sought by Mr. Gopalan was, of course, that of habeas corpus. I will spare you some of the definitions. We have got to move ahead, but I will try and explain these things as we go along, in case you, my dear viewer, are not having any legal background and hopefully not having any history with these things either. We will look at some of the provisions of law that were utilized in the hearings of this case. In this particular video, I'm going to restrict myself just to that. I'm going to split the discussion into several videos. The previous one was about almost 20 minutes long, which I think is a bit too much for technical topics. So the constitutional provisions that will be referred to or dealt with in this case, in the A.K. Gopalan case, are of course Article 32, under which the case came to the Supreme Court, and Articles 19, 21 and 22. Article 32, of course, is perhaps the most important significant fundamental right, without which none of the others would have mattered. Remedies for enforcement of the rights in Part 3 of the Constitution. The right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed, and the Supreme Court will have the power to issue directions or orders or writs such as habeas corpus, etc., for the enforcement of any of the rights conferred by this part. That is what Article 32 talks about, and that is the article which Mr. Gopalan utilized in approaching the Supreme Court. He sought a writ of habeas corpus that literally translates from Latin to where is the body, where is the person, do you have the person, bring that person before us, and you can no longer hold him with you, we are going to free that particular person. That is what the habeas corpus writ loosely implies. Article 19 is the right to freedom, including the right to freedom of speech and expression, the right to move freely anywhere in the country, the right to carry out any occupation, etc., and the right to personal freedom and liberty was, of course, what Mr. Gopalan had been deprived of, is what he claimed, and that is why Article 19 is also significant, as is Article 21. No person shall be denied the right to life or personal liberty save for under the procedure established by law. We have looked at Article 21 in the previous video, as have Article 22, which deals with the restrictions on preventive detention, that the provisions that we have looked at. There are also statutory provisions to be looked at during this case. All of them are from the one same act, Preventive Detention Act 1950, sections 3, 7, 12 and 14. Section 3, I have summarized it here, not pasted it, because reading through the actual legal language gets a bit tedious after a while. Section 3 basically empowers the government, whether the central or the state government, to order the detention of any person to prevent him from acting in a manner prejudicial to the defense of India, relations of India with a foreign power, security of the state, maintenance of public order, maintenance of supplies and services to the community, and so on and so forth. Now, as you can imagine, quite a few of these can theoretically be violated by any person who subscribes to who staunchly subscribes to the communist ideology, especially the maintenance of supplies and services to the community, strikes that etc. are not fomented, maintenance of public order, all of these things can be very easily violated if the state believes that they should charge us with that. Section 3 is quite broad, is what I am trying to imply. The reason I read out all of those, that entire list of manner prejudicial to defense of India, relations of India with foreign power, etc., is that there are exceptions where, well, we will come to those, where that subset of exceptions actually turns out to be something greater than the original. Section 7 is a very interesting one. Person detained by order under Section 3 shall be informed of the grounds on which the order has been made, shall be informed of the grounds on which the order has been made, and shall afford him the earliest opportunity of making a representation against the detention order. So if you have been detained per an order issued under Section 3, then Section 7 says that you should be informed of the grounds under which you are being detained, and you should be given the opportunity to make a legal representation. Then comes the interesting part, Section 12. Any person detained with a view to preventing him from acting in manner prejudicial to defense of India, relations of India with foreign powers, security of India, security of a state, or maintenance of public order may be detained for more than 3 months without obtaining the opinion of the advisory board, but nonetheless such detention cannot exceed 12 months. This exception is the one that I was trying to refer to. Let's look at Section 3 once again. The list over here is longer than that of Section 12. Section 12 basically says that in these particular situations, there is no need to even refer to an advisory board for extending the detention beyond 3 months. Otherwise, as the Constitution in Article 22 stipulates, that preventive detention cannot exceed 3 months unless the advisory board has given an opinion to that effect. But this section, Section 12 of that new act, says that there are certain cases when even that is not required. And which are those cases? Shouldn't this be a subset of the overall situation? Actually, as it turns out, it is not, because there is one phrase over here, security of a state, which does not exist in Section 3. That if you have if it is felt that you are likely to behave in a manner prejudicial to, and that long list, security of a state is not in that list. So this is not a subset of the list in Section 3. Is it an oversight or is it deliberate? We have no way of knowing. Definitely not 72 years after the fact, because anyway this act no longer is in force. But it is very interesting to note the use of the indefinite article a, security of a state, and not security of the state as it exists in Section 3 over here. And it is also to be noted that security of the state, the word state is spelled with a capital S, and security of a state, the state is spelled with a lowercase s, which quite clearly suggests to us that it was indeed the intention of the parliament to include security of a state and not the state of any province of India. That is what makes this tell us that it might not be an oversight. It's not just because there was a scramble to get this act passed before that 26th Feb deadline, but instead it was quite deliberate. So that is a quick start to the facts of the A.K. Gopalan case, and in the next video we will start looking at the arguments made by the counsel for Mr. A.K. Gopalan, Mr. Nambiar, and as well as the arguments made for the government, which were done by the Attorney General of India, Mr. M.C. Setalwal. So I hope to see you then as well. Hope you enjoyed this. Thanks for listening. Bye-bye.